Hi, everybody. Welcome. We're so happy that you're here with us today. I'm going to give you a few minutes to settle into uh, your Zoom room and get comfortable and get ready. I'm Julie Moose. I'm the executive director of the National Press Club Journalism Institute, and we're so happy that you're here with us today. This is going to be a very informative session on a topic that is very near and dear to my heart, which is media law and copyright and fair use, something that anybody who has worked in a newsroom or worked with journalists know is always changing, always challenging, and we're very, very fortunate to have experts in this to translate for us and guide us through. So there will be a lot of specific information, so we want you to know ahead of time that we will be sharing the slides after today's program, and we will also be recording this, so you will also get a link to the video. So lean in, listen, please ask questions. We want to know how this applies to you. So put your questions in the Q&A queue, and we'll answer as many as we can as we go. We will also save a little bit of time at the end, we hope, to answer questions as well. And now it's my honor to introduce our friends from Ballard Spahr, who will be leading this session. And I'm going to consult my notes very closely so that I get their experience right. First up is Chuck Tobin, who is a litigator, a former journalist, and the practice leader of Ballard Spahr's Media and Entertainment Law Group. He defends the media in libel and privacy lawsuits in state and federal trial and appellate courts across the country. Chuck is also a member of the National Press Club Journalism Institute Board of Directors, and I am very grateful for that. And then we also have Alia Smith, whose legal practice focuses on defending publishers and broadcasters against claims of defamation, representing them in litigation over access, Freedom of Information Act, subpoenas, copyrights, things that we'll be talking about today. And we also are joined and will be taught by Mara Gassman. And Mara's legal work focuses on litigating and counseling news, entertainment, and also other media clients in a wide range of matters, including First Amendment and intellectual copyrights. Before starting her legal career, Mara was a spokesperson for CNN in its Washington, D.C. bureau. So she also has had firsthand experience with journalism. Thank you three for being here, and thank you all for being with us. And I'm going to turn the program over to Chuck now.
Julie, thanks so much, and welcome everybody on behalf of Alia and Mara and I and the media law team here at Ballard Spahr. As Julie said, you are near and dear to our hearts. We really enjoy working with the hardworking journalists out there. We hope that you're staying safe and keeping your loved ones safe. And our job is to keep you legally safe. And in trying to do that, we are always delighted to team up with our friends at the Institute and present these webinars on legal issues that are confronting journalists. One of the areas of risk that's the most increasing to journalists these days on the legal front is copyright law. A generation ago, we would probably be focusing more on defamation law. Defamation is still a risk. There are still plenty of people out there who are suing under the defamation laws in the various states. But copyright is the biggest growing area that we've seen in our media law practice at Ballard Spahr. And especially in the digital environment, where the ability to copy and paste into your work is just so easy to do these days. There's been a real increase in the number of copyright cases. And the allegorical tale that we like to tell in these webinars, or sorry, to have to tell in these webinars, is on your screen right now. And it's the case where Daniel Morell, who is a professional photographer, a very noted and celebrated photographer, went to Haiti to film to take pictures of the earthquake, put some of the pictures up on his Twitter feed, and people copied and pasted them. And among the people who did that were professional journalists at outfits like Getty and Agence France Presse. And as a result, Morell sued them for copyright infringement. And his claim is pure and simple. He's a professional photographer. He earns his living by selling his works to each outlet, and that they infringed on his claim. The case went all the way to verdict, and damages were awarded in the millions of dollars for the copying and pasting of a single photograph or just a few photographs. So the risk is there, the magnitude is severe, the impact can be great, and the exposure is increasing with the help of programs and bots and apps like you see in the lower left-hand corner of your screen. There is a rising group of plaintiffs' copyright lawyers, plaintiffs' copyright agents who work with artists to post their work up online, sometimes to create traps to the unwary so that people do download and then create liability for this. Other times it's for the routine policing of your work. Policing is the term we use for keeping an eye on your copyright. Other people call it trolling in a pejorative sense, in order to earn damages and go after people for your copyright claims. However you look at the copyright issue, it is an increasing exposure to your legal well-being. And that's why we're going to spend the next hour rolling through some of the tricks and traps of copyright law for journalists and answering your questions along the way. So let's start with some of the basics, copyright basics. The initial thing that we like to dispel in these seminars is the notion that there's such a thing as the public domain that protects you, that because it's free to see on the internet, because it's free to access on the internet, therefore it must be free to use and take from the internet. Free to view is not free to take. Copyright law does not work under a public domain model by and large, unless the work was produced before 1925. If you see something before 1925, as a general rule, you're probably going to be fine. But if you see it on social media in the public domain for any work since then, if you see it on a Twitter feed, if you see it on an internet website, you click and paste, copy and paste at some somewhat significant legal peril if you don't follow the simple copyright basics. An area that we get a lot of questions about are government websites. And so we're happy to tell you that by and large, the federal government does not have copyright protection for works that it creates and it posts. Conversely, a lot of state governments do have written into their laws copyright protection, and those have been enforced in the courts. To throw out a couple of examples, there have been court rulings upholding the copyright claims for the state codes, the law books that are written by lawmakers in South Carolina and in Georgia. So with those basics, let's talk now about the principal ways that you might protect yourself. The two ways you can protect yourself from copyright claims, number one is to get a license, to get authorization from the person who created the work, and it's not always the person who posted the work, but to get authorization. And we're going to walk you through in the next hour a series of different steps you might take to try and do that. That is your first and best protection from copyright claims. And then there's a second round of protection, but it's really a fallback, quite frankly. And it's the fair use doctrine. A lot of journalists, most journalists have heard about fair use. Some of you are probably very sophisticated in doing your own fair use analysis. But one thing to keep in mind, and we'll underscore this later, is fair use is a justification for taking someone else's copyrighted work. And it is a very intricate analysis that you have to be schooled in, and you have to get some experience to really be able to work it through. And so let's talk about some of the specifics, and I'm going to turn the microphone now over to Alia.
Thank you, Chuck. So as Chuck mentioned, the first and best way to protect yourself against a copyright claim is to get authorization. And that is not generally too hard to do. Mara, we can go to the next slide. So in general, we as lawyers like to encourage you to get formal licenses, and that's going to protect you against all contingencies, all uses. We'll have all the bells and whistles with the I's dotted and the T's crossed. And you should plan ahead if you're doing any kind of long-term reporting to get the rights for the, the art that you plan to use with your story, and use one of these formal licenses that you get from your in-house lawyer or from other sources, including, for example, trade associations. However, we understand that a lot of times what's happening is that you are covering breaking news stories, and there's no time or ability really to get, a fully, vetted, perfect, lawyers love it type of license. So in that case, an informal license can normally suffice. And you'll see on the screen the types of things, that journalists have used in the past. They'll see an image, for example, that's posted on Twitter. They'll want to use that image, so they reply to the tweet saying, hey, can I use this image? And in general, that will suffice, although we recommend that your informal request to use someone's video or photo includes some specific elements. So let me talk about those. All right, so tips for an informal license. One of the things you want to do if you are sending somebody a DM or replying to their Twitter message or posting on their Instagram page is identify the work that you want to use. So if you're responding, for example, to a tweet that has several photos in it, you want to identify which ones you're asking about specifically. Maybe it's all of them, maybe it's just one, but you don't want there to be any confusion later about which work you got the right to use. Next, you want to state the purpose of your use. For example, do you want to broadcast it? Do you want to print it online? Do you want to print it in print? Do you want to post it in a window? Whatever it is that you want to do, you want to specify that in your request. And you might just say for all purposes forever. But you don't want to have a situation where later there's a dispute that the copyright holder thought you were going to be using it for one thing and you ended up using it for something else. So it's better to specify the use that you want to make. And then third, obtain the representation that the person who posted the image on social media or otherwise online is the creator of the work. Now, obviously, this person could lie to you, and you should, thanks. And you should do some due diligence to the extent that you can to make sure that the person who's granting you the rights is the person who's authorized to do that. And one thing you can do as part of that due diligence is get them to make a representation to you that they are the creator of the work. Because one thing that we'll talk about a little bit later is that copyright is a strict liability claim. And so if you get a license from somebody who is not the poster, but you really think that they are, you still may be on the hook for copyright infringement, even though you had a good faith belief that you had a license. So you really do need to do some diligence to try and make sure that you're talking to the right person. All right. Now, apart from a license, which as we discussed can be formal or informal, there's another way to get authorization, and that is through the terms of service or terms of use on certain types of websites. So you probably have heard of Flickr or Creative Commons licenses that exist on some clearinghouses for videos and photos. And that is a generally acceptable way for you to get free or low cost images. But there's a couple of things you need to think about when you're getting images or photos or video from one of these sites. Number one is to look at what the terms are of the license that's being granted. So Creative Commons licenses have a number of different variations. Sometimes creators will allow you to use their works for any purpose. Other times it's only for non-commercial purposes. Sometimes it's only for personal use. Sometimes they will allow news uses. So you need to make sure that the use you're planning to make fits within the license that's provided. Second of all, you need to look very carefully at what the attribution requirements are. And so, if it says you must state that this is provided courtesy of X person and put it in the lower right-hand corner of the photo, you need to do exactly that, because if you don't get the attribution exactly right, that license may not be valid. And then, one final point on this is that I think there is some confusion about whether social media sites like Facebook and Instagram and Twitter can themselves grant you a license to use someone else's works. And the general rule is that they cannot and do not. So don't fall into that trap. All right, we'll go on to the next bit. Another question that we get a lot having to do with permission is, in what circumstances can we use information that we receive from, for example, from a candidate's website or from a news release, press release, where the people posting this information clearly want it to be distributed and covered. And the answer there too is, again, to look at the terms of service and see what they say about whether you can use this material, because sometimes candidates will post on their websites photographs from very famous photographers and they don't have the right to give it to you. You'd have to go and ask the photographer. So you need to be very careful about what you pull from these sources. And luckily with a news release or a candidate for public office, they'll normally have a press person that you can talk to about these kinds of issues. But the bottom line is you just really need to read what the terms of service say. Normally, also, you need to think about the use you're going to make. If you are given a news release and you want to cover the information that's in the news release, often that will be allowed. If you want to save it and use it for some other purpose later, that might be a trickier question. So, be sure to look at the fine print. And I will wind up with a cautionary tale about authorization in a case that's settled, but I think provides some interesting guidance for us here. A couple of years ago, Fox News used this photo of Alexandria Ocasio-Cortez, just in a general story about politics and things that were going on in Congress. The photographer who took that picture of her then sued Fox News saying, you never got permission to use this photo. Now, the case got settled before any of the substantive issues about fair use or anything else got litigated. But I think this is the kind of thing that presents a risk that you should think about, going forward. There was no license, at least as alleged in the complaint. And as we'll discuss later, it's not necessarily a great fair use defense just to pull a photo of a famous person from the internet to illustrate a story that you're doing about that famous person. There are things that you can do to try and protect yourself, but in general, that's a risky thing to do. And so you need to think twice before doing it. And so with that, we'll then talk about our takeaways from the authorization before we get into the fair use part of things. As Chuck also mentioned, it's always safer to get permission than to rely on fair use. Because if you have a contract that says you can use this image or you can use this video, that is a lot easier, cheaper, and quicker to defend than having to litigate whether something is a fair use. As we discussed, permission doesn't have to be formal, but make sure that the person you are getting permission from is authorized to give it. At least do as much diligence as you can to make sure that you're not being duped in some way. As I mentioned, copyright is strict liability. And so even if you have every good faith belief that you were doing everything right, you still could be on the hook. Damages might be less, but you still potentially are going to have to litigate that case. So you need to be careful. And in general, license will work from a clearinghouse, which a lot of you have access to, like AP, Getty, other sources, or use a public domain site like Flickr, rather than just ripping content from the internet. All right.
Great. Thanks, Alia. So my name is Mara, and I'm happy to be with you today to talk for a few moments with my colleagues about fair use. So I'm sure that most of you here have a sense of what fair use is, and you've potentially even attempted to navigate the nuances of it in your own life and work. And so we just want to clear up some common misconceptions about fair use and to make it a little more predictable. For better or worse, fair use is one of those things that can be difficult to anticipate and predict. As some have sort of sardonically joked that the right of fair use is the right to get a lawyer, and that's because there is an element of it. There is a know it when you see it element of it. But luckily, there are some guideposts that we have in the law, that are in federal statute, and that that can help provide some level of predictability. So let's just talk briefly about those, and then look at some examples of how you can put those into actual practice. So when a court is considering whether use, so this is going to be after the fact, you've decided to use the work and you've hopefully used it in the safest way possible. And if it comes to litigation, the court is going to look at these 4 factors. And so these are also the factors we look at when we are evaluating whether to use the work and how much of it and how to use it. And these are non-exclusive. It's not a, you have to check all 4, you have to check at least 1. There's a sort of, it all goes into the mix. So the first is the purpose and character of the use. And so the court's going to be looking at whether, again, as you can see up here, whether it's a commercial use, whether there's some kind of educational use, and also if the use was transformative in some way from what the original use was. And that's really key to this analysis. Did you essentially take the photo or the video or the text that you lifted from, for example, a manuscript or a book, and just copy it to illustrate your own work, or were you commenting in some way about the work or altering the work in a way that gives it a new life and new meaning and new cultural relevancy? So that is the first factor, and some people consider it really the most important factor. So we'll talk a little bit more about that. The second is the nature of the copyrighted work, and this gets at the idea of whether the work is creative, fictional, highly artistic, or it's more fact-based. And the idea there is that copyright, the more artistic, the more creative, the more copyright should protect it, and facts are not protected. So that also is considered and goes into the mix. Third is the amount used in relation to the whole. This is both just the details of the amount. Is it a 1 hour video and you use 2 seconds, or did you use 30 minutes? You used a picture and you just threw up the whole picture? And it also gets to the idea of whether you use the real meat of the work, the real heart of the work, such that if the owner of the copyright wanted to try to sell it or use it him or herself, would you have sort of preempted their use or somehow undercut their market? And that really leads into the last factor, which is the effect on the potential market of the copyrighted work. Is this something that could have been licensed or sold, and by using it without paying for it, did you sort of take money out of the pockets of the copyright holder? And so a good illustration of this, which we think in a room full of journalists is important to raise, is the way in which you have to be aware that just because something is a news story, you may be working on a news story, but that doesn't mean that your use of someone else's copyrighted image in your news story would itself be a fair use. So we put before you these 2 photos embedded in 2 news stories. One obviously is speaks to the tragic death of Whitney Houston, and one is about what many people would think is a very important public interest topic, which is a fashion house deciding not to use fur anymore. Both important news stories, legitimate news stories, but query whether those photos are essential to the news story, whether these articles comment on these photos, or rather whether these photos are simply illustrative of the topic, of the people, and grab attention. I think most people, most courts would look at that and say it's the latter, and that these are therefore not a fair use. They're merely being used to illustrate a story. They're not the story itself, and a license should have been obtained, because whoever owns these photos, even where credit is given, as it is in the Burberry photo, and actually in the Whitney Houston photo as well, is not sufficient. These owners have the right to grant or deny permission to use them. My colleague Chuck is going to talk in a few moments about what is more likely to make your use fair. What are some of the practical things you can do to increase your likelihood of having a fair use and not landing in hot water in court. But before we get there, let's sort of talk about what makes something not a fair use. And probably many of these things you can glean from us going through the factors and from the discussion of the photos, but you just put a fine point on it. Content used to enliven a report is not going to be enough. Just having a photo to grab eyes or illustrate the topic is not enough. When it's the dominant element of your report, but it's still not something that you're commenting on or analyzing, that's going to make it less likely to be a fair use. When you're taking a work that has never been published or disseminated, that is also a less likely to be a fair use. So the prime example of that is if you're reporting on some sort of public figure or fictional work, and you get an advance copy of a script or a manuscript, and that has not been circulated to the public, it has not been released, and you publish it in whole or in part. That is, there may be news value in that, and that's something you may want to talk about with your editors, with your in-house lawyers. But if it has not been published, it is less likely to be a fair use. Number 4 is sort of gets to this market idea where there's already a market for works, like a licensing market. Taking someone's work without paying for it is less likely to be a fair use. The idea being that you could have called up and tried to license it. We talked about the very first factor, educational nonprofit uses are going to be more protected than commercial uses, and 5 gets at that. Are you using it in an ad of some kind, native advertising perhaps, or are you using the work in an actual news story? If it's promotion or advertising, it's less likely to be a fair use. And then last is a little bit of a cautionary tale. You may have licensed a work or gotten some sort of authorization for a work, or perhaps even have a work in your archive because you did use it in a way that would be a legitimate fair use, and now it's in your archive, and 6 months later, 2 years later, it gets pulled up and used in another story. Well, that you'll want to look at that because to determine and make a fresh fair use analysis, or determine whether the authorization extends, because just having it in your archive is going to make it less likely to be a fair use if you just pulled it up without going through that same analysis. And so to wrap up this section, let's take a little bit of another cautionary tale, or let's look at a story that played out in real life in stages. So many of you may have followed this story, or at least you're aware that President Trump was known for attending weddings at his property, Mar-a-Lago. And there was controversy about that. So certainly it was the topic of news coverage, and whether that was appropriate, if that was presidential, if that touched on any of the litigation surrounding how he was benefiting allegedly from his office and his personal holdings. And so there you have foundationally an actual legitimate news story. So Then, a guest at one of these weddings takes a photo, a very clear, direct, great photo, sends it to a friend. And this guest was not a professional photographer. He was an investment banker at Deutsche Bank, took the photo, sent it to a friend, and the friend from there started circulating it. And it pretty quickly ended up in lots of, on the websites of lots of news organizations, including, as you see here, TMZ, and among others, Esquire.com, which is owned by Hearst. And in fairly short order, TMZ promoted its coverage, and other news agencies did via Twitter, as they do. And the photographer, Mr. Otto, started commenting on their posts and on their tweets, and indicating that he did not consent to their use of his photo for free. A photo, again, he just shot on his iPhone. And probably, according to the court decision that ensued, he didn't intend to sell it. He was not a professional photographer for whom licensing was a big portion of his work, but nevertheless, it was his photo, and by taking it, he had a copyright in it. He didn't have to register it. So despite the informality of it, he had a copyright in the photo. He sued, and indeed, the court sided with him and against the news organizations, indicating that this was not a fair use. And specifically, the court determined that simply because there's a newsworthiness to the overall event of a wedding at Mar-a-Lago that President Trump attended, despite not knowing the folks getting married, this photo to illustrate a story about it is not an appropriate fair use, and licensing would have been required. So this is this is one that I think a lot of journalists, based on years of counseling, would have thought, at least would have wanted to make the argument that this would be a legitimate fair use because of the newsworthiness of it. And it just causes us, I think, to pause and remember that because of the strict liability nature of copyright, and because of the desire to protect copyright owners, that in and of itself is generally not going to be enough than just the news value alone. All right, so now getting out of the woods, out of the dark of the night, and talking about what is going to be a fair use is my colleague, Chuck.
Thanks, Mara, and thanks for that good summation. Before we talk about a little further about fair use, it's often helpful when we're counseling journalists to have them try and frame the issue in their mind this way. Copyright is protected by the Constitution. It's a concept that the founders put into the Constitution, that there should be the right of artists to protect their works, their right to earn money from their works. Because of that constitutional provision, Congress enacted the Copyright Act, which it amends from time to time. That tells the lawyers of the world and the artists of the world what their rights are and what their rights aren't, and how that plays out in the courts. The fair use defense is part of the Copyright Act, but what it actually means, how it actually works, is left to judges. And what Mara and Alia and the other lawyers at Ballard Spahr and other copyright lawyers do is we take the Constitution, we take the fair use defense, we take the judge's decisions, the precedent, and we advise you on each of the factors that have resonated and with the courts and protected journalists. And we look to cases like the Otto case and the Morell case, where the journalists were not protected, where the artist was given vindication. And we try and counsel you on what might or might not make for fair use. And so one way to think of it is that the Constitution and the statute protects the artist and allows them to exploit things. You can sell your photographs copy by copy. You can license your photographs if there are photographers watching this. But what the fair use defense allows is for you to build on other people's work, to use other people's work to create new art, to create new journalism, because after all, human civilization is a series of progressions based on the work and the labors of other people. And the fair use defense is a way to balance out the constitutional and statutory right of artists to exploit their own works. And so what makes something more likely to be fair use, to build on other people's work, are some of the factors that are up on your screen right now. So for example, if you are commenting on a newsworthy photograph or a newsworthy piece of art, you are more likely to be within the realm of fair use, because the law, the courts have recognized that if the document itself, the art itself, becomes newsworthy, becomes part of public commentary and debate, there has to be some leeway to show that, and we'll show some examples in a minute. On the other hand, the contrary to that are some of the examples that Mara showed you, which is where you are using the art to tell the story itself of Donald Trump crashing a wedding. It's not a comment on the photograph, it's use of the art in lieu of paying the photographer money in order to use the art in your publication. So commentary on a piece of art is an area that, generally speaking, falls within the realm of fair use. Otherwise, and Mara alluded to this, using small snippets or segments of the art to create your own story, to move your story along as an element of telling your story, the fair use decisions generally protect that. One of the myths we consistently hear about is whether there's a limitation on video, for example. There's a myth out there, or music, of the 6-second rule. I can use 6 seconds because the law tells me that I can use 6 seconds. That's not accurate. It is, as Alia and Mara have told you, it is a complicated matrix of 4 factors, and the length of the use folds into that analysis, but it is not the be-all to end-all. It's not a free ticket out of a copyright lawsuit. If the copyright work has already been published, there may be less of a risk that a court is going to find it's not fair use, because the artist has already exploited, the writer has already exploited the market, by and large, by the first right and the redistribution of their work. And so that's another factor that courts look at in the fair use analysis. And then finally, we always caution photographs shot by professionals. Right-clicking and left-clicking a photograph that was shot by a professional is probably an invitation for a court to find it's not fair use. If that's what you're doing and you're dropping it in a story to illustrate an event or to tell a story about the person who is in the photograph but not comment on the photograph. And it's also more likely to get you sued because, again, copyright law is to protect the professional photographer and his or her ability to resell their work and not to allow you to take their work in lieu of paying the license fees. And so to show you a couple of illustrations of how this has worked and how it plays out, Cindy Crawford posed for a photograph that was published in Marie Claire. It was a fairly recent event. She posed in a photograph, and the artist who took the photograph, the photographer John Russo, took a look at how Marie Claire displayed the photograph. And as we'll see, I think in the next slide, Mara, if you would advance it, thank you. The photograph was largely retouched around her midsection, her abdomen, and it was retouched to cut out some of the contours, some of the lines that appeared in the original photograph. And there were other cosmetic changes made before it was published. Well, the photographer himself looked at that and felt that he needed to make a social statement about that Marie Claire should not have felt the need to have a woman in her late 40s retouched in order to celebrate her beauty and her glamour, that was just unnecessary, and it was counterproductive as a social statement. And so he put out a tweet, and he put out side by side, because he owned the right to do that, because he owned the photograph, or retained at least the right to redistribute his own photograph. And so he put them up side by side in commentary, and it was picked up, if you'd advance the next slide, Mara, in a lot of different journalist outfits in talking about why the photograph itself had been retouched and the social debate that that photograph contributes to. But the photograph itself was the actual subject matter. And as you'll see, people added other elements to it as they went along in commentary and pictures of tweets of different other people commenting on that photograph. And because of that, more likely than not, all of that commentary and the fact that the photograph itself was the subject matter, and it had already been published, the photograph itself in Marie Claire, all would go into this fair use analysis and probably make all of that journalism come out fine if the photographer or Marie Claire were to sue over the use of that photograph. Another recent illustration for you was Vanity Fair and some photography that appeared in a photo spread. They took Oprah and Reese Witherspoon and Nicole Kidman and Tom Hanks, all of whom were photographed individually, and put them all together as a celebration of various celebrities. And then they had a photo spread on the inside of the magazine. And you can see the cover and part of the photo spread up on your screen right now. And a lot of people came along and noticed that if you look real carefully, Oprah has 6 fingers in one of the photographs, and Reese has 3 legs. You can see the imperfections in the way these photographs were edited together, and probably edited from individual shoots into a single photograph of Reese that was then aggregated with a photograph of Oprah. And that sparked a lot of criticism. There's in every generation an inevitable debate about journalism and telling stories accurately, and rather retouching photographs, and what are the boundaries of editing photographs that are ethically permissible. And some people just like to have good fun poking at what they see, imperfections that they see in the news media and the mass media. And so this prompted a lot of commentary, a lot of criticism, a lot of humor about the photo spread. And you can see people put them up and circled the imperfections and the different parts of it. People posted them with tweets and commentary, and all of that, again, is more likely going to be fair use because it's commentary on the photograph and it's mixed with other elements. And so underneath the Vanity Fair photo spread, you'll see we've provided you with a series of tips and takeaways for fair use analysis, what will more likely than not make your work a fair use. You want to add context, you want to add new information, you want to add commentary, you want to add analysis. Again, the statute protects the artist's right to sell their work to you if it's an illustration for a story unrelated to the art or the photograph. But it also permits you to create the fair use defense, to create new work and to create commentary on the art itself. And so you can really help your case by adding context, new information, commentary, or analysis. You want to use only as much as you need to use. So you want to crop, you want to abbreviate, you want to annotate, you want to shrink. Oftentimes, we advise TV stations to have the talent standing back and have a monitor really small so that the resolution is not that great on whatever the commentary is going to be, whatever the art is going to be about the commentary, so that it is not a substitute for simply dropping the art into your piece rather than paying the license or royalty fee. So use only as much work as you need. If it's video, a brief excerpt, and only in the context of other material. Alter the cropped image, include text, images, markers, crop to focus on specific elements. When you do that, we always advise to retain the copyright notice of the original artist, but understand that simply taking someone else's work and dropping it in a news story and saying copyright Chuck Tobin or courtesy Chuck Tobin, a lot of people put that courtesy title in there, and then when they get into litigation, the artist is asked, did you give them the right to do that? No, I didn't. Well, how do you feel about that? Well, I don't think that was courteous at all, frankly. So courtesy notices, copyright notices, they're really not a be-all to end all, but if you are taking someone else's work, we do recommend that the copyright travel with it. And then consider whether you're using the heart of the work. My colleagues mentioned that earlier. A couple of allegorical tales from the litigation. The U.S. Supreme Court had a case a number of years ago, Zucchini versus Scripps Howard. It was a right of publicity case, which is a sister claim to copyright. And what the news story was about on the Scripps station was about a man, a visit of the circus to town, and the guy being shot out of the cannon. Well, the artist claimed the right to exploit and sell tickets to seeing himself shot out of the cannon. And that's exactly what the news station showed. The Supreme Court on his publicity claim said, you showed the heart of his work. After all, nobody goes to the circus to see the artist walk out, take bows, give flowers to the audience before he gets up on the stage and gets shot out of the cannon. You took the heart of his work and you owed him money for doing that. Similarly, Harper's Weekly or Harper's Bazaar published an excerpt of President Ford's memoirs. When they were first published, they got an advanced copy, a courtesy copy, on an embargo basis, I suppose, and they went ahead and published the excerpt where Ford talks about pardoning President Nixon. It went all the way to the Supreme Court on whether that was a copyright claim violation as to Ford's publisher. And the Supreme Court in the majority decision said the most noteworthy part of President Ford's entire term, the main reason people would buy this book is to read about why President Nixon was pardoned. And by putting that out there, the magazine had taken the heart of his publication, the heart of the book. And by the way, I just realized that was Nation magazine, one of the pitfalls of doing live TV, live Zooms. So it was Nation who had done the excerpt of President Ford's memoirs. So these are kind of the tips and the traps. But again, think of it: am I creating a new work? Am I commenting on the art? Or alternatively, do I just not want to pay or have availability to a license and am unable to make my arrangements with the artist? Alia is going to talk now about embedding, which is kind of a hybrid issue on the internet. So Alia?
Do you perhaps want to answer maybe just a couple questions? We've got a couple good fair use questions that maybe we could throw at the panelists before we wrap up with embedding. That work for you?
That sounds terrific.
Great. So we have a question about Creative Commons licenses, and they say they're open to non-commercial use, and are news uses generally considered non-commercial? What about nonprofit news?
So this question, as far as I know, has not been litigated. My view is that you have a very good argument that a news use is a non-commercial use, because generally speaking, news is not considered commercial speech. But I can't tell you with any kind of certainty that that's how a court would come out on that. And so I think, your safest course of action is to try and contact the poster, whoever put that on Flickr or other Creative Commons site, and double check that your use is going to be authorized. But I still think you would have a good argument that it's a non-commercial use.
And I'll add a cautionary tale to that on Creative Commons specifically. We've litigated a couple of cases where journalists have taken photographs from Creative Commons, and then the photographers have come after them, even though they've made them available on Creative Commons. Creative Commons allows the artist to put the terms of the license in, and the cases we've had, there was a very specific notation where the artist's name had to travel with the work, and where CC : Creative Commons, courtesy of the artist's name, the photographer's name. And for whatever reason, the newsrooms did not do that, did not credit it in this specific way. So when looking at open sources like Creative Commons, not only do you have to keep in mind, not only should it be some comfort that they're available, but you need to look very specifically at what the terms of use are and what the artist has said needs to happen in order for you to have that free license.
No, I mean, I think that's exactly right. And it's a particular problem, I think, with broadcast uses, because in print, it's typical, I think, to see the attribution. And sometimes that's not always the case in broadcast. So broadcast media need to pay particular attention to that, I think.
Great. And we have another great question, which is, can news media copy posts and photos from Facebook or Instagram without worrying about copyright issues? It sort of touches a little bit on what you were talking about earlier, Alia, but there's also another twist, which is this questioner says, I am teaching a journalism class at a university. What are the copyright issues if I'm sharing material from the web with my students on a university platform? So it's sort of a dual question about taking from social media and showing it in an educational setting.
Chuck probably has something to say about this, but I will just say, when I talk about embedding in a moment, we'll get to part of that embedding from social media, which has some twists and turns. But I want to emphasize, and I think Mara and Chuck have said this too, that taking something off of social media does not give you a license to use it. It's not an automatic fair use. You have to go through the analysis or else get a license. So please be aware of that. Generally speaking, I think in an educational setting where you're distributing something to a small group of students and not necessarily posting it widely, that will generally be considered a fair use. But I will defer to my colleagues who have presented on fair use.
Sure. I'll add the caution that if you right click and left click off social media, you can't be sure that the person who posted is the person who created the photograph. And ultimately, the license has to come from the artist, the photographer, the creator, and not the poster. And so it's a magnified problem that social media creates. In terms of the educational setting, the nature of the use, nonprofit, educational, and journalism are part of the fair use analysis. Again, it's a 4-factor test with lots of court interpretation. I would agree with Alia, if it's a small amount of the work and it's distributed to a limited number of students, limited audience, you probably have a good fair use defense. If you were teaching media law and you just copied into your syllabus the entirety of Clay Calvert's mass media law, one of the leading works in mass media law taught at the undergraduate levels, I would think that the publisher and Professor Calvert would have a very good copyright claim against you because you've taken the whole work and given it to your students rather than, and you've exposed the university, frankly, rather than putting it on their to be ordered list and making the students pay for each copy. Good question.
Yeah. Alia, we have a questioner who would like to know, in the Ocasio-Cortez Fox case that you referenced, did Fox provide a credit to the photographer in the caption, or did they post it without a credit?
I don't know the answer to that off the top of my head, but I think it does provide an opportunity to point out that that doesn't matter for copyright analysis. You are not absolved of copyright liability just by posting an attribution. And so sometimes it might help you in some circumstances or put you in a better negotiation position. But posting a credit is not one of the factors that is considered under fair use. And so if you don't have a license and you don't have a fair use, it's not going to matter whether you included attribution.
And one way to think about that, because we get that question a lot, usually after the fact. Somebody will come to us and say, but I put a copyright notice in there. I don't understand why I have this demand letter from the company representing the photographer. And, a way to think about it is that copyright stamp may help with their publicity, may let people know the origin, but it doesn't put their children through college. It doesn't put food on their family's table. And that photographer, particularly a professional photographer, makes their livelihood by selling the copies of their photographs, not by selling the copyright notice.
Great.
Good question.
So we've got more great questions that we will get to shortly, but we just wanted to give that little, get through a few and give that little taste. Alia is going to talk to us about embedding before we move on to the rest of the questions.
All right, I will try and make this quick so we can get to those questions, but we get a lot of questions about embedding, which, as most of you probably know, is the process by which a publisher takes code from another website, like a social media site or other website, and actually sort of pulls the image so that it appears on their own website. They're not actually making a copy of it. It's just the code that's there. And for a very long time in this country, that was generally considered not to be a copyright infringement because there was no actual copy being made. In fact, instead it was just this code that was pulling the image from somewhere else. And so we used to advise people, you know, generally speaking, you're probably going to be safe if you embed rather than making a copy to place on your own server. That rule has come into a significant amount of doubt recently because of a couple of cases, most notably one in the Southern District of New York involving a photo of Tom Brady talking to the manager of the Celtics about whether Kevin Durant was going to potentially join the team. And this was in the Hamptons. Bystander shot this photo of them. A friend of his, kind of like in the Otto case, posted it on Twitter. And then, you know, news media all around the world grabbed this photo to talk about, you know, whether Kevin Durant was going to be coming to the Celtics. The photographer sued over the use of this photo, and most of the websites say, wait, we didn't copy the photo, we only embedded it onto our website. And at that point, the court in the Southern District of New York held, no, you can still see it. It's a display of the image. You can still be on the hook for copyright infringement. And so that's just one court. So I can't tell you that the rule has definitely changed, but there is no definite rule now. And so you have to be careful even when embedding. And so the advice that I normally give is that, you know, the best practice is to get a license. If you can't get a license, you still want to make it a fair use to the extent that you can. Comment about, for example, the social media frenzy surrounding this photo of Tom Brady and the Celtics owner. You know, add your own commentary, crop the picture, put it in the context of all the tweets about it, and, you know, whatever you can do to increase the likelihood of a fair use defense. Those are the most important things to do. I will say, however, if you have the option to embed something and you don't have a license for it, it is usually going to be safer to embed than to make a copy and post it on your own server. It's not a get out of jail free card, but you have some arguments there in a way that you don't if you just make a copy. So that is the current state of the law on embedding. So now I think hopefully we have a few minutes for the remaining questions, Mara.
Yeah, and if we don't get to all the questions, we can follow up directly via Julia's help. So, so if your question doesn't get answered, we can follow up with you afterwards. So, we've got a question from Kim. If a subject hires, I guess the subject of probably a news story or a feature piece hires a photographer, do I, the publisher, the writer, need permission from the photographer or the subject of the piece, or both? And it doesn't matter if the photographer was a professional, paid, or a friend.
Great question. The answer is yes. If you want to be free from copyright liability, you need a license from the photographer who created the photograph. You do not need it from the subject of the photograph in order to protect yourself from copyright. And it does not matter whether the photographer is a professional or an amateur. It may affect whether they know enough, are sophisticated enough, will care enough to bring a claim or get a lawyer, but the law does require a license under those circumstances. Let me just also say, a lot of you who are out there are freelancers, and some of you are journalists working for news media organizations. Licensing is your first and best protection. If you're within a news organization, you have in-house counsel or retained outside counsel like Ballard Spahr available to you. If you have questions, if you have doubts, your first line, your first call should be to your in-house counsel or your news managers to get you involved with in-house counsel or outside counsel. If you are a freelancer untethered to an organization, then you have resources like the Society of Professional Journalists, the investigative reporters and editors, other affiliate groups who often perform the same function and get you the help that you need.
This next question is always a fun one and comes up during political campaigns. Someone asks, musicians often complain that political candidates use their work without permission. Is that a viable claim?
So that can be, I'll take this a little bit complicated because in part it depends where they are. So for example, if President Trump is holding a rally in a stadium or in a music venue or something like that, then often that venue will have licenses through music licensing associations like ASCAP to be allowed to use that music. But in other circumstances, typically, you are gonna want a license. And then there have been a lot of complaints about that.
And there have been successful claims litigated in the courts by artists against campaigns, usually because they don't agree with the politics of the candidate who's using their music to pep up a rally. And so it's a very good question in a very ripe area.
Is there a fair use defense in using a screenshot of a web page to show how an image looks on that page instead of pulling the image itself? And Ali, I think this sort of gets to what you referenced earlier in terms of the things that you can do to make an image look different. Do you want to speak to that?
Sure. I mean, as we've been saying all along, there are no absolutes with respect to fair use. But I would say that if you want to comment on something that has been on a website or on a social media page, it is generally a better idea to, sort of get the screenshot of the whole thing rather than isolating the specific photo. And then your story should be about this photo in the context of the web page or the social media post and what's going on with respect to commentary around the photo or debate about it or the salaciousness of it, whatever it is, to keep it about the photo and the controversy or news information surrounding the photo itself. So yeah.
We have another question, which I think is salient and worth just doubling down on. Roger asks, how can copyright protection apply for any photo taken by a non-photographer? In two of the examples, these were just everyday people taking iPhone shots, and yet they claimed copyright protection. I think I'll say that I personally do understand the reaction that's embedded, the surprise that's embedded in that question. And so I think webinars like this are really valuable because sometimes the law doesn't necessarily accord with our expectations or intuitions, but the reality is, yes, a person becomes a creator just by virtue of creating that work. And sometimes that's as simple as snapping it on an iPhone. Technology has made that a lot easier. And a person doesn't have to be necessarily a professional. And in fact, in fairness to this area of the law, there have been people who have captured really important, interesting things and made money by circulating them. So frequently you'll see after some kind of news event, like a bridge collapse or a landslide, some passerby got the video and posted it, and there'll be a sort of a flurry of commentary on their Twitter, asking for permission, licensing it, and there are entire businesses that are dedicated to helping amateurs monetize that by by being sort of the gatekeeper for that licensing. And so, you know, it is a way for even non-professionals to sell, to monetize their content. And yeah, you don't have to be a professional to have a copyright. So it's very democratic in that way. And we have a lot of other questions, but Julie, I think probably we're getting to the end and we'll need to address these in an individual basis. Is that correct?
Yeah, that would be wonderful. Thank you guys so much for offering to do that. And thank you all for the questions. They're really terrific. And thank you again for spending time with us. Thank you, Chuck, Alia, and Mara. I can tell from the questions and the polls that you guys have learned a lot, and we're so grateful. So when the pandemic started a year ago, the Institute waived all of our registration fees, and that saved tens of thousands of dollars for all of the participants like you guys here today. So we're counting on you to support work like this with a donation. And I'm going to put the link in the chat, and we thank you for your support in coming to this program, in engaging, in asking questions, and in, we hope, donating. And we hope you'll give us feedback about your experience today so that we can design programs for you and other journalists and members of the public that are the most valuable. So we'll send you the links to do those things shortly. We'll include the link to the recording of this program and then also the link to the slides. And again, thank you all so much for being here. Stay well, and we hope to see you again soon.